Okay, welcome everyone to our space here at the Mason County District Library in Ludington. We welcome you all in person and those of you on Zoom and at other libraries throughout Michigan. I am Robin Seymour. I'm the head of adult services here at the library, and together with Thomas Trahey, who's our head of circulation, and Brooke Portman, who is joining us from Ann Arbor. She is the founder and director of the Abondia Center, which is a nonprofit organization exploring arts and ideas that matter. We're here for the January installment of our Cairns and Beacons series, and we work to find our way in a post-COVID world as the theme of this series. So we're very thankful to see so many smiling faces, both new and recurring to the series. So it's excellent. Thank you so much. And with that, I will turn it over to Brooke.
Thanks, Robin. Hello to everyone. These are trying times, to borrow from a famous fiction writer. But here we are making our way through them. I want to thank you all too, together with Robin and Thomas, for coming, for joining us. Those who are brand new to the series are in for, we hope, a treat. And those who have been coming regularly, we have a topic and we'll continue to do that. I hope you enjoy it as well. We want to first thank our donors, which is the Michigan Humanities, as well as the Michigan Arts and Cultural Council. They are not the only donors, because those donors are supported by all taxpayers who pay state taxes and all people who pay federal income taxes. So the Arts Council is supported by state taxes and the Humanities is supported by federal taxes. So thank you. So when you're cursing under your breath on April 15th or whatever the date is this year, please at least say, well, at least organizations like the Mason County District Library and Abondia Center are doing some good programming with my tax dollars. To review the series a little bit, briefly, Cairns and Beacons, as Robin said, finding our way in a post-COVID world. We developed that title simply because once COVID was over, it was Thomas and I at that point. Robin hadn't yet been hired by the Mason County District Library, and we were trying to come up with a series. We had done one during COVID called Shifting Landscapes, everything shifting underneath our feet. And, as we were like everybody else, as COVID kind of wore on and we were ready to get up and out, we also had time to really have those things sink in, that we wanted to change. We wanted to be a part of the change, things that not actually turned out to be as done as well as we wanted, called things like equity and healthcare, homelessness, poverty, infrastructure, all of those things. Lo and behold, as Thomas and I were beginning to put together the program, we both looked at each other and said, oh God, I'm exhausted. I can't do this. We can't do this. We're just two people. What the heck? And then we looked around us, and as we were working a little bit, I said, I think our title needs to have something like Beacons in it. And Thomas, about a few days later or a week later, who knows, back in those days, I was here in Ann Arbor, he was back there. He said, I've got another word for our series. He said, Cairns. And I went, I love it. Cairns and Beacons. Thomas, I have no idea what a cairn is, but I think it's great. And then he said, it's a path. It's the stones, that at the beginning of a trail or somewhere that say, here's a safe place to go. It'll take you to another spot. You can go from there to where else you want to go. We all know a beacon is something that tells us this is a nice place to go, or stay away from here, red light, green light kind of thing. And so we thought that topic, that title worked. So then we had a list of about 35 topics and then dwindled it down to the 8 that you have. We have done 4 series. So we did good and evil first. You know, why not start with the small stuff, you know, at the very beginning? But we actually didn't look at what is good and evil. We looked at how is it that we are set up, or we set ourselves up to commit evil and not call it evil, or to do good, but say, oh, you know, I just did what any other human being would do. What is it that is in our Constitution to do that? That was our first title, our first session. Our second one was looking internationally about how people who are really way below poverty can survive, can find that programs can be done so that they can lift themselves up. And it's series of programs that we here now in the United States have begun to do, called guaranteed income or universal basic income. And we wanted to first start out, because we're going to end the series looking at guaranteed income here in the United States, and in fact, right here in Michigan, and in fact, right here in Ann Arbor, we are beginning a guaranteed income project. Took a while for it to get through the city council. And so we want to look at why is there this friction about it? Because what the international programs show, there are 10 years of evidence that if you give people money, cash money, they handle it well. So all of our fretting that they're only going to go buy liquor, or they're going to go do something awful with, you know, themselves, or leave their families, is not true. The third session was called, The Middle Out. It was done by Michael Tomasky, who is the editor for the New Republic, and has a book out called Middle Out. And it's part of what both the right and the left, it started it. It's about bottom up, middle out. It is how do we help the poor, the really, really poor, and the working poor. Our last topic last month in December was neoliberalism or Reaganomics. And what was it? Why did it start? Why do people think now, even from both the right and the left, that its time has come and something else needs to be in its place? So now we're on, I was going to say this semester, my old, there are a lot of educational people here who will understand that slip. But now we're looking at the Supreme Court, and Thomas will introduce that tonight's topic. Our next two topics after that, right in a row, are about the political parties. So we will look at Republicans first in February, and Sheila Krause from Ludington. She is the chair of the Mason County Republican Party. She will talk about what she sees for the future of the Republican Party. And in March, now we have a change of date there, and you'll hear more about this, but it's going to have to be on the 5th, because our instructor forgot that he has a seminar course that he has to teach because of the time difference and all. So we're going to move it to Tuesday, March 5th. But he'll be talking about the Democrats. And he's going to be really looking at, he and 3 others did some research after the last election, looking at who is really behind getting Biden elected. And it was a surprising find, and one that you still don't see in the newspapers. And it'll be interesting to see if they still see the 2 groups that were highest, Blacks in the rural areas and whites who had moved to the urban areas, both voted in the same ways. And that was very surprising to them. And so they're going to be looking at and sharing with us what they think is going to happen with this one. We will close in April when we look at universal or guaranteed income here in Ann Arbor. So that's the full series. That's the, how can we make our nation better? These are just 8 stopping points. There are many, many others, but it was really to give you some ideas about what might be done. Normally, I stop here and have some kind of poem about step by step, brick by brick, that nobody can do it overnight, that we all have to work slowly but deliberately. And other than having that intro, I'm not going to do that. I am going to read a poem, but it's about stepping back and just enjoying. things. And I think that we all need that in, whatever time it is, for whatever reason. When I was putting this together, it's like, I think we need a little bit, or I need a little bit of shoo. So here goes a poem by Mary Oliver. She was a National Book Award winner and a Pulitzer Prize winner. She died in, I think it's 2019 at 83. It's called Invitation. Oh, do you have time to linger for just a little while out of your busy and very important day, for the goldfinches that have gathered in a field of thistles for a musical battle, to see who can sing the highest note, or the lowest, or the most expressive of mirth, or themes tender? Their strong, blunt beaks drink the air as they strive melodiously, not for your sake and not for mine, and not for the sake of winner, but for sheer weight and gratitude. Believe us, they say, it is a serious thing just to be alive on this fresh morning in this token world. I beg of you, do not walk by without pausing to attend to this rather ridiculous performance. It could mean something. It could mean everything. It could mean what Rilke meant when he wrote, "You must change your life." So that's the poem for the evening. And now I am going to turn the mic over to Thomas to introduce our speaker for tonight. We had a wonderful, fantastic conversation with Stephen Winter when we met with him. I guess it's this past week. So Thomas, take it away.
Thank you, Brooke. Thank you. Okay. I'm just going over the assumption you can hear me both online and here. So as we thought about the topics for this particular program, for this Cairns and Beacons program, and I've always been a fan of the Supreme Court. It's been in the news a lot in the past couple of years over, controversy over appointments or unpopular decisions or accusations of ethical violations. It's really been in the news a lot. But even before that, I used to, decades ago, listen to Nina Totenberg read the transcripts before they'd allow recordings in the courtroom. And she would read back what the justices had to say or cross-examining the litigants, both sides seeming to have a legitimate claim. And the justices seemed to really pose hypotheticals to the litigants. And, what in this scenario, would this still hold? Would your argument still hold if we take it to the extreme and look at this from a different point of view? Or what about in this situation? I really dug that. I was a big fan of that. And it seemed to me that the justices were carefully weighing the implications of these cases and what would happen, what is going to happen if we make this ruling one way or the other. Fascinating to me. And I also had a lot of respect for people that would seemingly vote against their own political beliefs or their personal biases because they had a higher calling, a higher standard. They had to uphold the law. I was naive and idealistic, and I think, which becomes even more apparent now as I talk to people who really know about the Supreme Court, including Stephen. So I still have some of those ideals. I still think that nobody should be above the law. And I still think that the justices should decide the cases on the merits and not their own political biases or beliefs. But here to talk about the Supreme Court, we would have been hard pressed to find somebody more knowledgeable than our speaker tonight. Stephen is the Walter S. Gibbs Distinguished Professor of Constitutional Law at Wayne State University. He's been teaching law for 37 years. He's written more than 25 papers on examining the intersection of law and humanity. Winter began his law career in 1978 with the NAACP. He argued in front of the Supreme Court. He's worked on more than 20 cases in front of the Supreme Court. His book, Clearing the Forest, Law, Life, and Mind, make the case that the better we understand how our own minds work, the better we understand the law. I'm delighted to present Stephen Winter. Stephen, welcome.
Nice to be here. Thank you for inviting me. I'm glad that Thomas confessed his naivete, because otherwise I'd be in the position of embarrassing him by, because I intend to try and demystify the Supreme Court and the law for you a little bit tonight. So the first thing I want to say about the Supreme Court is that it has always been, and will inevitably always be a political institution. This is true in two senses, but the second sense is the one that's interesting. The first sense is the obvious one. We know, going back to de Tocqueville's Democracy in America in 1835, he said there's hardly any political question in the United States that sooner or later does not turn into a judicial question. With our practice of judicial review, which in the course of my remarks I'm going to call into question, that political questions, as descriptively, historically, have always ended up in the Supreme Court. But the more interesting sense, that wouldn't be a problem. Let me put it that way. If the law worked something like what Thomas was describing, which is, I think, the conventional colloquial understanding of how the law works, that there's a set of rules, or in the case of constitutional law, there's the constitutional text and the rules that it announces, and that the judges, in a logical, objective manner, can understand, interpret the meaning of those rules, and then apply them in a unbiased, unpolitical, or in objective way. That's sort of the official story of law, and that's what most lay people understand. But I think it's terribly wrong, and not just is it wrong descriptively, but it has that way of understanding the law has negative, really severe negative consequences. In Harper Lee's To Kill a Mockingbird, Calpurnia, who's the Atticus Finch's housekeeper and nanny, explains to one of her fellow domestics. She says, "First thing you learn when you're in a lawn family is that there ain't any definite answers to anything." The dialect aside, Calpurnia is extremely smart, and she knows what she's talking about, because later in the book, Harper Lee tells us that she learned to read by reading Blackstone's Commentaries on the Law of England, which was the single most important legal treatise of the 18th, 19th century. And that's, I think, the most important thing to understand, is that there's nothing about any aspect of the law, and something about the Constitution that's clear and straightforward. I'm going to walk us through a couple of examples. I'm going to start with one that's very much in the front pages these days, Section 3 of the 14th Amendment, right, which is the one that the Colorado Supreme Court said disqualifies from candidacy anybody who's engaged in insurrection against the United States, having once taken an oath to support it. And one of the questions is, does it apply to a president? So here's the language of the Constitution, the relevant language. "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, if, having once taken an oath, they engage in insurrection, or provide aid and comfort to insurrection." So there are a couple things to notice. There's a list of offices that are specified, but offices that for which insurrectionists cannot stand. They include senators and representatives, people in the Electoral College, but it leaves out the president and the vice president. That's a little surprising, and one could read that part of the statement and say, oh, it doesn't apply to the president, he's not listed. Then there's the catch-all, or hold any office, civil or military, in the United States. So maybe he is covered, right? Maybe a president who, I'm sorry, maybe a person who's once taken an oath and supported insurrection can't stand for president. Now it gets more complicated if you learn, once we learn that an earlier draft of this section of the 14th Amendment specified the presidency and the vice presidency as offices that the provision covered. And sometime between that draft and the final draft, they deleted those two. So that would seem to indicate that okay, then the first reading was correct, right? That it's not listed, so it's not covered. When the final version was being debated in the Senate, one of the senators asked whether this applied to the presidency. And at least one of the proponents of the amendment said that it did because the any other language, right? So if you've traced the argument thus far, it was an argument for Trump, followed by an argument against Trump, followed by another argument for Trump, followed by a response against Trump. Which is the right reading? There's no absolute answer to that, right? You can emphasize the fact that the earlier draft specifically included the president, and then they deleted it in the final draft. You can emphasize the statement of one of the proponents saying that that didn't work or change. But that's not definitive because he's only one of the proponents, right? And other people may have had different readings, including other people who voted for it. And this is just what's typical. This is what Calpurnia is talking about. This is typical of law. Why is that the case? The answer is, I think, actually very straightforward. And that is we have a naive understanding of how language and communication work. The naive understanding, which is the conventional understanding, and we all rely on it on some level, actually all of the time, is that meaning is in the words, that the speaker, the author, puts the meaning in the words. We read the meaning, we read the words, and then we take the meaning out of the words. So it's a very kind of objectified picture, right? The words are little containers for meaning, and the author puts the meaning in it that he or she intends, and a competent reader receives the container and then takes the. But if you reflect on that little story for a moment, the meaning can't be in the words because the meaning has to be in the minds of the people who write the words in the first place. And it has the same meaning, or something like the same meaning, has to be in the minds of the people who are trying to interpret it. So the meaning is not definite. The meaning is going to be relative to the sets of understandings, the knowledge, the sets of background understandings that and the context in which the speaker and the interpreter, the hearer, are acting, and that can vary. And here's the second problem: most of our words have both broad and narrow meanings. I like to start all my first-year law classes with a simple rule prohibiting animals on the bus, right? The rule doesn't say much. It says no animals on the bus. We all understand it because we all have an understanding of what buses are for, and what the potential problems or hazards are of having animals loose on a bus, both discomforting the passengers or creating safety problems. But that's not really what the rule says, right? Literally, right? We're animals. And so if we took the rule literally, I see there's a question in the chat. Do you want to just hold that for the Q&A? Literally,
It's up to you. It's up to you, Stephen. But usually what we do is hold those till the end and then,
the answer to that question is sometimes. The question was, our earlier drafts of the amendment take into account? And the answer is sometimes. That is to say, right? If it helps your argument, then you'll cite it. If it doesn't help your argument, then you can say, well, that's just a previous draft. It's not what they adopted. So my point is that given the ambiguities of language, right? For the court to decide a case requires an active interpretation, and there isn't a single clear, correct, or objective answer. There are different possible answers. Some may be better than others, and courts will structure their arguments to support the conclusion that they're arguing for. So the statements of the proponents will be relevant when it works. I mean, one of the things I love to point out in constitutional law, the conservatives in particular, and people who claim to be strict constructionists love to cite the Federalist Papers, except when it contradicts what their position is, and then suddenly they don't cite the Federalist Papers anymore. So that's the, and so this is part of Calpurnia's insight, right? She understands that language is ambiguous, that there are the laws have to be interpreted to be applied, and that there are different strategies that one can bring to get different answers as well as to get better or worse answers. Let me give you let me give you another example. This is not going to be a litigated case. The president has to be a natural born citizen. John McCain was born in the Canal Zone, Panama Canal Zone. Ted Cruz was born in Alberta, in Canada. Are either of them eligible to be president? Most people assume yes, but does natural born mean you have to be born within the geography of the United States? Or does it mean that you have to have just been a citizen at the moment you were born, right? In Ted Cruz's case, for example, his mother was a citizen, his father was not. Under the federal statute that regulates citizenship, being born to an American citizen mother is enough to convey citizenship automatically. Although at the time, being born to an American citizen father was not enough to convey citizenship. It required more. So seems like a simple provision, but turns out it's not only not simple, but it's also kind of impossible to answer. We can only go about thinking how to answer that question if we understood why the framers put that provision in. And it's not at all, we actually don't fully understand why they put it in. There's no explanation of why they insisted on that. They did say it was enough to be naturalized citizen at the time of the Constitution. So, but not if you're not a natural born citizen and subsequently naturalized, like Arnold Schwarzenegger, he's not eligible for president. Not 100% clear why. I'm going to give you another example, but this is I think I would characterize it as a more egregious one. Second Amendment says a well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. In District of Columbia versus Heller in 2008, Justice Scalia, writing for a majority, said this creates an individual right to own and carry weapons. And how did he reach that conclusion? He said, well, the first clause doesn't really matter. It's just a preface, so we can ignore that. Let's look at the operative words of the clause: to keep and bear arms. To keep is to own or possess, to bear is to carry. So see, an individual right to keep and bear arms. The only problem is that's not what the amendment says, right? It says a well-regulated militia being necessary to the security of a free state, right? Seems to be saying that certain kinds of arms for certain kinds of purposes are what we're concerned about. And let me come back to the no animals on the bus. How do we know that humans aren't animals for purposes of a rule prohibiting animals on the bus? The answer is because we know what a bus is for. And so the concept of the bus frames our understanding of animals in this context. We know that the buses are for carrying humans. And so nobody in their right mind would have meant to say that no humans are allowed on the bus. They must have meant some other subset of animals, right? The same thing's going on in the Second Amendment, right? It says the frame, which we want you to think about weapons, is the militia is really important to the security of a free state. And so we're going to protect people's right to own weapons with respect to the practice of belonging to a militia. Now, the militia has an interesting history, some of which we talked about at great length on Tuesday. And I'm not going to go into that now, although I'll be happy to do so if in the question and answer if people are interested. But you could see there are strategies for reading this amendment narrowly. There are strategies for reading it broadly. The court opted to read it broadly. Yeah, let me just pause there for a second. The invitation asked me to talk about some recent Supreme Court cases, and I think that probably the most relevant for our purposes is the student loan case. where Biden had forgiven student loans, and the Supreme Court said that was not within his statutory authority to do so, and they applied something called the major questions doctrine. So I want to read you the statute that was at issue there. Notwithstanding any other provision of law, unless enacted with specific reference to this section, the Secretary of Education may waive or modify any statutory or regulatory provision applicable to the Student Financial Assistance Program. The waive or modify any statutory provision. That seems very broad, right? And that's what the president relied on, right? In an emergency, he had the power to waive or modify. What does the Supreme Court do? It says, well, modify means make a small change, and waive must mean the same thing. So if Congress meant to give the president a much broader power, they should have said so, right? That's basically the import of the major questions. They should have said so clearly. And Justice Kagan writes in dissent, well, waive or modify means everything from make a very small change to abrogate the whole thing, right? That's what waive means, right? To abandon or abrogate the whole thing. So Congress did specify, right? And in a really wonderful line, Justice Kagan is a terrific writer and capable of a really good turn of phrase. Quoting it from herself in an earlier opinion, she said she called the major questions doctrine, she said, is a get out of text free card, right? So the court purports to read the text and to be bound by the text, except when it doesn't like the outcome of the text, in which case it reads the text narrowly and then says, well, if Congress had meant the greater import of these same words, it should have said so more plainly, right? So you begin to see how much wiggle room there actually is in legal reasoning generally and constitutional law in particular. So why does this matter? Well, this matters a lot. I think I gave a more detailed talk about the Second Amendment to some non-law colleagues here at Wayne, and one of the people said one of the other departments said in the question answer says, if what you say about the Supreme Court and the law is true, that I'm very upset. And I said to him, you should be upset, right? Because the problem of judicial review is precisely the problem that an unaccountable appointed group of officials, the Supreme Court justices, get to have the final say on issues, the vast majority of which, because we purport to be a democracy, the people themselves should be deciding. So the Supreme Court judicial review is, as a general matter, an anti-democratic practice, one that undermines democracy. Sorry, I wanted something I wanted to read you if I can. Yeah, there it is. Historically, in the early part of our history, in the pre-Civil War period, the Supreme Court actually only invalidated 2 statutes in a period of over 60 years. No, actually 70 years, I should say, from 1789 when the Constitution was ratified till 1861 when the Civil War starts. The Supreme Court only twice invalidated a congressional statute. The first time was in the case that established judicial review, Marbury versus Madison, and the statute involved was a technical statute about the jurisdiction of the Supreme Court, so not an issue that would have seemed of great legal or constitutional moment, although it was of some political moment at the time, because it was the lawsuit involved an appointee of the Adams administration who was suing to receive his appointment, which President Jefferson and Secretary of State Madison refused to deliver to him. The Supreme Court basically said it couldn't reach the issue because the jurisdictional statute it was operating under was unconstitutional. The second time was Dred Scott when the Supreme Court upheld slavery. And the court thought, historians I think almost unanimously agree, that Chief Justice Taney thought that by ruling on the constitutionality of slavery, saying that Congress did not have the power to prohibit slavery above the I forget what the number of the parallel was, but it's the line that does not divided Missouri from Kansas from Nebraska. Under the Missouri Compromise, Congress could not prohibit slavery north of that line because it was a deprivation of property without due process. Tawney thought that he was putting the issue to rest. And of course, it had the opposite effect, right? It further radicalized the anti-slavery forces, leading ultimately to Lincoln's election, which was the precipitant of the Civil War. Something like that is true of the abortion debate in 1992, when the Supreme Court upheld Roe in the Casey decision. The plurality opinion, there was no majority opinion for the court, but the plurality, the determinative opinion by Kennedy, O'Connor, and Justice Souter offered the promise that by resolving the question, they would take it out of politics and defang the otherwise quite partisan and quite polarizing debate over abortion. Of course, that didn't happen, and ultimately the Supreme Court did a 180, and quite recently in the Dobbs case struck down the overruled Roe and Casey, and left it to the states individually to decide on the questions of reproductive freedom. The illusion that by taking things off the off the table, so to speak, from politics, that we can resolve otherwise divisive debates is one that's never been borne out historically. It is the theory of liberal constitutionalism that that's the role of the Constitution. Yet it doesn't do that, because it can't do that, because the court has no methodology that is objective in the sense that it claims. No methodology that could not make both sides happy, that not to be expected, but at least to pacify each side that something neutral has been done. But at the end of the day, there's nothing neutral to do. These are difficult questions that we have to fight out in the ordinary way. Now here I'm paraphrasing John Bradley Thayer, who is a famous constitutional law professor of the late 19th century. He wrote, "Great and indeed inestimable are the advantages in a popular government of judicial review, the power of the judiciary to disregard unconstitutional legislation. It should be remembered that the exercise of it, even when unavoidable, is always attended with a serious evil, namely that the correction of legislative mistakes comes from the outside, and the people thus lose the political experience and the moral education and stimulus that comes from finding out the question in the ordinary way and correcting their own errors." Right? So it's not just that it compromises democracy, it undermines democracy, because people want to say, well, we'll let the Supreme Court decide it, and then we lose our own capacity, our sense that we're masters of our own destiny through the political process, that we can make our own decisions and make our own mistakes, fight it out in the ordinary way, and correct our errors when we found we've gotten it wrong. So what you might ask then, is the Supreme Court and the Constitution for, especially what's the Supreme Court for? Here the answer is, I want to say equally conventional. That is to say, it was understood at least since the New Deal period, and for most of the balance of the 20th century, although this consensus started to unravel in the 1990s, not long after, around the same time as the Casey decision, that the Supreme Court's true function, you can put true in scare quotes if you like, that the best function, the meaningful function for the Supreme Court is to act in ways that preserve democracy itself. This has an insider's name amongst constitutional lawyers. It's known as footnote 4, because this theory was articulated by Chief Justice Harlan Fiske Stone in 1937 in a footnote to an otherwise unremarkable case involving condensed milk. But the premise was that ordinarily the court should defer to any reasonable decision made through the political process, essentially with two exceptions. I'm reducing it a little bit, but basically with two exceptions. When the question itself goes to the fairness and effectiveness of the political process, So laws that constrain free speech or laws that affect the right to vote are ones that the court should be policing to make sure that the political process, the democratic political process, is open and fair and functioning the way it's supposed to. And then the second principle exception, where set of cases where there is an important role for judicial review, laws that disadvantage discrete and insular minorities. Obviously had in mind the prototypical example of African Americans, because we're still long before the civil rights movement at this point. We're still essentially in the age of Jim Crow in the South, right? In that context, the concern of majority, or I should say, let me say it this way, a minority that's essentially frozen out of the political process is vulnerable to the tyranny of the majority. And in those cases, there's a special role for the court to act to protect to protect the democratic process, to protect democracy itself. That would recognize that this is not, how shall I put it? It's not objective, right? It's to recognize that the Supreme Court role is value-based, right? That the Supreme Court is enforcing certain values, democratic values, not somehow neutrally, objectively opining on truth, justice, and the American way from on high, but to generally leave things to the political process, which, if the court's doing its job and making sure it's open and fair, the political process will be the best safeguard of our liberties, which was, of course, always the understanding of democratic theory. So here's where the rubber meets the road. What's at stake in this kind of view? Think about the Dobbs decision, when Justice Alito writes for a majority of the court in Dobbs that Roe, he says, was egregiously wrong when decided, and that reversing it. His argument was, and see, we're being good for democracy, right? We're preserving democracy. We're sending it back to the states where citizens can fight out the issues with respect to abortion and reproductive freedom in the ordinary democratic process. And that's a great argument, or it would have been a great argument, if only it were true, which is to say, right, that there's a certain amount of sleight of hand, to put it tactfully, on the part of Justice Alito, because just 2 years before that, the Supreme Court had refused to deal with the gerrymandering problem, right? The problem of gerrymandering, that you can set up your districts so that not only can you create safe districts for your partisan side, but it's actually possible to create districts in a closely divided electorate, which we have. It's actually possible to create districts that will reliably elect a minority government, right? I have a long example with actual numbers that I run for my classes, but in a closely divided electorate, right, the basic move is called packing and cracking. You put all of the other side into one or two districts, right, so that they can elect the person of their party's choice, but 90% they elect them by margins of 90 to 10 or 95 to 5, right? So you've concentrated all of the voters for the other party, and then you spread out your voters so that they're a slight majority in all the other districts, and you can end up with very lopsided outcomes. In Wisconsin, which is one of the cases that went to the Supreme Court, the Republicans at one point had 48% of the vote and 60+% of the seats in the legislature. And when they, in the next cycle, when they had a majority of the vote, they had, I think, 52% of the vote, they had 66% of the legislature, right? So, and that's by artfully distributing your voters, or actually artfully drawing your lines so your voters are distributed in just the right way. So it's all well and fine to say we disagree about abortion, we'll let people fight it out in the political process. But unless the court does its job, which it deliberately didn't do, and make sure that that apportionment works in a way that makes the political process fair, then the court's just cooking the books, as it were, right? First it rules in a way that the playing field is tilted, and then it says, oh yeah, well, we have to defer to the the unfair political process. So that's the view of constitutional law that I try and press on my students. I suppose I can probably talk longer, and I'm probably haven't talked as long as I'm supposed to have. But I think that's a good point to stop and take questions. Yeah.
Good plan. So if you want, usually what we have is Brooke will read the chat questions. That way you don't have to focus on them.
Okay.
Okay,
However you like to do it, fine with me. So.
then we can start with that one.
So and I mean, I've already answered this question, but let me just say a little bit more. Until the recent court, it was understood that even if one understood, it was widely accepted that even if one understood language as being more clear than I've tried to show you that it really is, that what went on in the debates leading up to the adoption of a statute or provision of the Constitution is context that informs our interpretation of it. This was generally referred to as legislative history, because the debate largely occurred in the context of interpreting statutes. But it was long been true in constitutional law. Let me give you an example of a conservative opinion that I strongly disagree with. The 11th Amendment says the judicial power of the United States shall not be extended to include cases brought by citizens of one state against another state. Supreme Court in 1890, in the case of Hans versus Louisiana, said, well, it seems to say that if somebody from Georgia sues the state of Louisiana to collect on a contract, that we can't hear that. What if somebody from Louisiana sues Louisiana, right? That doesn't seem to be covered by the literal language of the amendment. Supreme Court says, but when they adopted the amendment, the whole problem was they were trying to assert the principle of sovereign immunity, that states can't be sued. And though they may have said it funny, right, that's what they meant, right? And they go through the entire history of the adoption of the 11th Amendment. So that was sort of standard. I don't actually agree with that opinion, but a perfectly good conservative opinion that relies on the history of the adoption of the amendment, right? That is not restricted to the literal meaning of the text. In fact, right, the holding of sovereign immunity, even when the plaintiff suing the state is a citizen of the same state, the amendment clearly excludes that case. Excuse me. Later, they extended it to foreign governments suing the state, and the Supreme Court said behind the language of the text are postulates that limit and control, once again going beyond the text. In the last 20 years, Scalia was the main proponent of focusing on the text of statutes in the 1990s and early 2000s. In the Roberts Court, and especially now with the conservative majority over the last, I'd say maybe decade, they've been much more textualist, both in reading statutes and the Constitution, except when not. Right, and they have evolved new doctrines like the major questions doctrine, so they can get at, if the text is too general and they don't like the obvious import of a text that's too general, then they have a side doctrine that they can invoke. So the answer is sometimes yes, sometimes no. The way to think about law, and this is counterintuitive for most lay people, and it takes a while for law students to figure it out and understand it, is it's really a set of argumentative conventions, a set of tools that lawyers and judges use. The tools are devices for shaping outcomes, but they're not like a measure, right? They're not like it's not a tape measure. It doesn't, they're not precise. They don't give you a particular outcome. They give you different ways to structure the reasoning and reach different outcomes.
Oh, Brooke, you're muted.
So we have a question from Jordan first.
Yes, right. I'll read that one aloud so that everybody can hear. And I was speaking, but I had myself muted. So here we go. I recall from law school teachings a political question doctrine. That is, that the court would refuse to weigh in on questions that they deemed purely political. And yet, as you suggested, every political issue inevitably becomes one for the judiciary. So what is your opinion on the vitality of that doctrine now? Is it all but dead?
No, just the opposite. It's a great question. And what you recall is absolutely correct. There is something called the political question doctrine. It says these are the kinds of questions which the court cannot decide. Generally not because they're political in the lay sense. What the political question doctrine really means to say is that it's a question, it might even be a question of constitutional law, but it's one that the Constitution itself consigns to the political process and not to the court, right? So in the gerrymandering case, that's what they did. They invoked the political question doctrine and said that there are no legal, judicially manageable standards for us to decide this. So it just has to be left to the legislatures and the political process to fight out the fairness of districting, of gerrymandering. So it's very much alive. It's invoked like it is like every other legal rule that I've suggested, one that reasonable lawyers and judges can disagree on, and they do disagree on. That's so it can be invoked some places where it probably shouldn't have been invoked. I think the Rucho, which is the gerrymandering case, is an example. I think the court should have decided that and should have decided on the merits, that it was in fact critically important to democracy for them to have done so. And then there are other questions where they say it's not a political question, but it seems to me that they're obviously wrong. My favorite one of the obviously wrong, there's a case called Zivotofsky, which involves recognition of Jerusalem as the capital of Israel. And prior to the Trump administration, the official State Department policy had always been not to recognize Jerusalem as the capital of Israel. So our excuse me, our embassy used to be in Tel Aviv. Now Trump moved it to Jerusalem. But what was at issue was a child of American citizens born in Jerusalem and whether they could have Israel listed on their passport as place of birth. The State Department had previously refused to do so. Congress passes a statute giving people the right to have Israel listed on their passport as place of birth if they're born to American parents in Jerusalem. Chief Justice Roberts says, well, this is not a political question. It's just a question of statutory interpretation. We do that all the time. And so denies a political question. It goes back down to the trial court, rules for Zivotofsky, comes back to the Supreme Court. A different majority now reverses on the ground that this is not a decision that Congress or the courts can make. This is a decision that only the president could make, which if you followed the way I set out the logic, that should have made it a political question in the first place. So there is a political question doctrine, but it's no more objective than any of the other legal doctrines.
Thomas has several questions there from people around the table, right?
So the next question there is one can relate ways of thinking in law to Thomas Kuhn's idea of paradigm changes. I guess that's what the question is, whether one can relate to. And I think that's a fabulous question. So I personally am a Kuhnian. So I think the answer is absolutely yes. What Kuhn says basically is that all of science is paradigm dependent. That is to say, you have some background theory or understanding, and all of your data is always necessarily being understood in light of those understandings. And that's on his account, which I find quite persuasive, science changes not so much by getting new data and getting better picture of reality. It changes by what he calls something like a Gestalt switch, right? Seeing things in a new light, but because you're looking at it from a different perspective. I mentioned Thomas in our long very enjoyable conversation on Tuesday. Both my dad and my brother are physicists. My dad's passed away, but my dad was a physicist. My brother's a physicist. So my dad in the late 40s, early 50s studied metallurgy. right? The dimes and the quarters with the copper centers, he developed that. He can't. That's his
Oh.
patent. That was his invention. Um, when he was in graduate school, there were two ways to think about metals. The old way, the older paradigm, was that metals were viewed as a solid. And all the experiments and all of the theories were premised on the idea that metals were solids. The cutting edge paradigm back in 1952 was that metals were actually a fluid. And that if you thought about metals as a fluid, you could do all sorts of really interesting things with it, including make copper and nickel bind together, which is right was the basis for his for the sandwich coins, right? The coins with the copper centers. The problem was how to get two different kinds of metals to actually fuse and not peel off from one another over time. That's that's as much of the science as I know. I can't explain to you exactly how he did it. Although I did see the machine that did it when I was a little boy. That's there's a special rolling mill that was able to get but here's the kicker. The metallurgy department at NYU in New York ascribed to the new paradigm that metals were fluids, and that's where my dad got his PhD. The metallurgy department at Yale ascribed to the old theory that metals were solid, right? And nobody could get a PhD out of Yale unless you ascribed to the view of the senior professor in the department that metals were solids. So all of the graduate students of my dad's generation who went to Yale did their research on the assumption that metals were fluids. And then they wrote up their dissertations on the thesis that metals were actually solids. And, but yeah, we can do these interesting things with, right? So it's a wonderful example of Kuhn really in action, right? They had to take all their data that they had assembled with one view and then rejigger it and fit it into, right, fit these square pegs into a round hole in order to get their PhDs from the department at Yale. That's but I think it's a very astute question, right? Basically, another way to sort of simplify Kuhn's view, right, is that all data are theory dependent. The data don't speak their own objective meaning. It's how we interpret the data in light of the perspective that we take on it. And that's essentially what I was saying about human language generally, human knowledge generally. That's largely the argument of my book, A Clearing in the Forest, that Thomas referred to. Great question about Kuhn, that terrific connection.
I've got several questions piling up here. The first one, I'll read this. My understanding is that the basis of Roe is actually the recognition of a right to privacy. So won't Dobbs cause a chain of other reversals?
It could. And Thomas wants it to, right? That he's in his concurring opinion, he points in that direction. I'm not sure I would predict that that's how it's going to go, although I certainly would agree that that's a possibility. I think that the reaction to Dobbs has been quite unequivocal, that the court really is out of step with the American public. Historically, the court has rarely been long out of step with the dominant views of the American public. They can sustain an unpopular view for quite a while, sometimes decades, but ultimately it usually catches up with them. And that phenomenon, that prediction, follows pretty much from everything I've said, although not necessarily obvious or direct way. That is to say, this is the way I argue it, put it in my book. We expect the law to be objective. If what I've explained to you is correct, there is no objectivity to be had, right? So if you're a court and your audience, the public, expects you to be objective and you have no objective tools, the only effective way you can sell them on your stuff, on your decisions, is if they more or less cohere with the expectations of the audience. Because if they cohere with the values and expectations of the audience, it will be perceived as, oh yeah, that's right. That's the law, right? But if it's way out of step with what people are thinking, then people are saying, well, what are these Supreme Court judges doing? They're imposing their own values, which is what happened in the aughts, the teens, the 20s, and into the 30s. And then eventually, if President Roosevelt threatened to enlarge the PACTA court, right? And the court backed down. The court backed down really suddenly, right? And really obviously, right? The two cases, one upheld the National Labor Relations Act called Jones and Laughlin, involving the steel company, and the other upheld minimum wage law in, I think, Washington State, called West Coast Hotel versus Parish. They're referred to as the switch in time that saved nine. Justice, because justice, and that's universally referred to as a switch in time that saved nine, because Justice Roberts, who had voted with the conservatives, voted with the New Deal liberals in those two cases. And so instead of being 5-4 striking down progressive legislation, it was 5-4 upholding it. Shortly after those two decisions, there were several vacancies on the court that FDR was able to fill with New Dealers, people like Senator Black, William O. Douglas, and Felix Frankfurter. So then that, at that point, then there was a large majority of what were then liberals, the Democratic appointees.
Can I ask you a question about that?
Sure.
Just, I know probably a thimbleful, but because the interpretation of the history was more on the president's side about he got his hand slapped. But what you just told was a story of, well, he got his hand slapped for a few minutes and then figured out how to get what he wanted.
Yeah, so I mean, he didn't cause the vacancies. So he got what he wanted ultimately.
Oh, right. But I mean, but what you said is, switch in time saved nine.
Right. He lost the battle but won the war.
Yeah, right.
He lost the battle but won the war. So if the court packing statute failed,
yeah, right.
it was a very public failure.
Right.
But the court, but what he wanted was a court that would uphold New Deal legislation. He got that even before he got to add appointments to new justices to the court. So yeah, he definitely lost the battle but won the war. That's so that was a long period, right? That's the counter example, not the counter example, the example from the other side that makes the same point but from the other perspective. I was just talking about this with a colleague the other night, is the Warren Court. So the Warren Court was incredible, and this when I say that courts have always been political. This is not unique to the Warren Court, but it's an example of that. So the Warren Court was incredibly savvy, right? It was just out in front of the public in Brown versus Board of Education, pushing the public in a progressive, more equitable direction than large sections of the country clearly were ready for. The South was obviously not ready, but probably was more radical even than mainstream public opinion in the United States at the time. But they understood that. So first they ruled that segregated schools are unconstitutional. And then in Brown 2, they say, take your time. We're not going to push the issue, right? And they basically didn't enforce Brown till long after Dr. King and the Civil Rights Movement were making very visible successes on the political stage. So they kind of got out a little bit in front, then pulled their horses in, waited for the country to catch up. Then when there was a wave of public opinion that it could ride, then said, okay, now we're going to order busing, right? And that didn't happen until the late 60s. So I think around 67. And then on criminal justice, you sort of see it in reverse, right? They liberalized criminal procedure. They recognized, as had the Hughes Court in the early 1930s, that criminal justice in large portions of this country was, how shall I put it, primitive, shall we say, or non-existent. And so they nationalized, right? First, they required lawyers in Southern death penalty cases, right? Then they required lawyers in all federal cases. Then in the early 60s, they required lawyers in all felony cases, right? Gideon versus Wainwright. But there was substantial backlash over the course of the 1960s. So in 1968, when late in the Warren Court, a little bit before Chief Justice Warren retired, he authored an opinion that liberals were aghast. It was called Terry versus Ohio, and it gave the police the right to stop people and frisk them for weapons on less than probable cause. So it was like, we've been pushing the envelope on criminal justice. We're going to give you something back, right? They were very much in touch with the dynamic between public opinion and public values, and constitutional interpretation. Another example, triangulating it from yet another angle. For most of our history, the Second Amendment was understood to refer only to the militia. In the 1930s, cases called United States versus Miller, the Supreme Court made that explicit. In Heller in 2008, the court basically just ignored, I mean, it talked about Miller, but basically said we don't have to pay any attention to it. What's the big difference? The biggest difference, and Reva Siegel at Yale has written about this very persuasively, is that constitutional law changed on the ground first. In the 90s, the gun rights movement focused on the Second Amendment and on a broader interpretation of the Second Amendment, and gradually built up a very substantial movement and a major shift in public opinion about the right to own weapons as an individual right. By the time the Supreme Court gets to it in Heller, it's got some public wave behind it, right? So values are changing on the ground first, and the Supreme Court looks like it's leading, but in fact it's either following or it's leading, but it's just at the cutting edge, right? With it's not operating, not operating sort of in a vacuum. Dobbs would be the counterexample, but we'll see what happens with Dobbs, right? That's the interesting thing is this, obviously, you all know this, that in every state that has, there are only about 17 states that have a referendum, but in every state where reproductive freedom is put on the ballot, even in very conservative, very red states like Ohio and Kansas in particular, overwhelming support. So Supreme Court clearly got that wrong, and we saw that in the last midterms. I don't make no prediction about what's going to happen in 2024 because I think a smart person doesn't predict the future.
That's
Smart person doesn't try to predict the future. He or she knows that you can't do that.
Let me ask this next one here. Are there rules for behavior for Supreme Court justices? And is there any way to remove a justice for cause?
Yeah, so justices can all be impeached.
Oh,
That means yes in theory and no in practice.
yeah, okay.
Right, because you need
Yep.
you need a majority of Congress to vote to impeach, right? And Congress is not right now controlled by the Republicans, and then you need a 2/3 vote in the Senate to convict.
Oh,
Right? So,
This may sound naive, but what is an impeachment, an impeachable offense for a Supreme Court justice?
famously, Gerald Ford said, impeachable offense is whatever Congress says it is.
If your daddy gave you a present.
High crimes and misdemeanors, bribery, treason, high crimes and misdemeanors, that's the standard for all of them. Clearly that's just like all those other constitutional provisions, only more so, right? That what counts as a high crime or misdemeanor. There are a lot of law professors, including a lot of famous law professors, who have strong opinions on what counts as an impeachable offense, but they're not the same opinion.
right.
Right. So some people maintain that it's only for something that is a crime. Other people maintain that high crimes and misdemeanor was a term of art and doesn't refer to ordinary crimes, but refers to some specialized subset. Yet others claim that high crimes and misdemeanors are things like bribery or treason, which are betrayal of the public trust. I think that's a very reasonable interpretation, but the main point is there's at least I've laid out four, because the first one was Gerald Ford's. It's whatever Congress thinks it is. People like to make fun of the Ford students like it because my students like it because it accords with their cynicism. But there's something to be said for the Gerald Ford position, right? I mean, in a democracy, an impeachable offense ought to be what a majority of the citizens think it is. Right. That's what makes it a democracy, right? And that was the general position that I was taking with respect to all other constitutional issues. So I think that makes a lot of sense. We wouldn't want to live in a political society where we impeach people because we didn't like the way they dressed, or right, or even because we just strongly disagreed with their politics, because that would be that kind of the world which we're living in, right? They're impeaching Biden. Why? Nobody. That's the they want to impeach the Secretary of Homeland Security, Mayorkas. Nobody's even remotely claimed that he's committed an impeachable offense yet. We've yet to hear what that might be. That would be a bad self-destructive world for us to live in, which is the world we seem to be living in. There was a famous 20th century judge. His name was Learned Hand, which is a great name for a judge. He was a federal judge in New York City, and then he was appointed to the Second Circuit, which is the Federal Court of Appeals that covers New York, Connecticut, and Vermont. And it, at the time, was the most important of the courts of appeals. Probably today, the District of Columbia Circuit is. But he said famously in a address he gave at Harvard Law School, he says, a country that has a spirit of moderation, I think he said a society that has a spirit of moderation, no court need save. A society that's lost the spirit of moderation, no court can save. Right. And I used to think when I was a law student and a young lawyer that Learned Hand was an old fuddy-duddy. And the older I get, the smarter he becomes. So that's
Can I ask you, what resources are there to enforce court rulings?
At the end of the day, I think the court and most savvy political actors understand that there are none. That Felix Frankfurter, Justice Frankfurter, was most famous for this position, which he held to a degree that one could say he held it to a fault. But his view is that the court functioned only because people believed in it, right? That they had a certain amount of kind of judicial capital, and that it had to husband it and spend it really wisely. That's the fault part, right? The premise, I think he was right. Hamilton said something to that effect, right? Hamilton says, having neither the power of the purse or of the sword, the Supreme Court would be the least dangerous branch, right? But the idea is it has the power. The power it has is social power,
right?
And the power it has been quite substantial. So I think really in 2000, when I tried to explain to neighbors and friends and acquaintances why Bush versus Gore was egregiously wrong, which I think it clearly was, and most constitutional law professors, like 98% of us, predicted the court would never do what it did in Bush versus Gore, just as we predicted it would never strike down Obamacare. But and basically we were essentially wrong in both cases, more obviously in Bush versus Gore. It was very hard to explain to people why it was wrong, because most people's reaction was, they're the Supreme Court, they say so, it must be true, that must be the law, right? So it takes a lot of explaining. The court knows that. So the Dobbs example is a nice one, right? Nobody paid much attention. Everyone paid attention when Dobbs came down because they understand that, right? And that's on the front page of all the newspapers. It's in your feed. It's in your social media feeds. But the case that really mattered was the one saying that gerrymandering was a political question, right? And that flies under the radar, right? That's the so the court, they're fairly savvy. Some of them more savvy than others. Chief Justice Rehnquist was particularly savvy. He understood how to structure decisions so that they were under the radar. And one of his favorite techniques was to say, you have this constitutional right. Of course, that's very important. Oh, but guess what? No, there's no remedy for violation of that right, or nobody has standing to sue. There's no way a court can enforce that right. And that was I refer to him as a constitutional termite because it was a very effective strategy, and he was a very smart man. I would say, unfortunately, he was a very smart man, and he was really good at it. That was
I do have another.
I'm going to come back to the Thomas question. The second half of it said,
Oh, yeah.
Thomas is against substantive due process. This would put other things at risk. How would moving to Privileges and Immunities Clause change anything? I think Thomas thinks that it would. I think the answer is it wouldn't, right? So the one thing that Thomas is right about, but this supports my argument, not his, is that the people who wrote the 14th Amendment, it's probably the case based on the history, the best history that we have, as I understand it, it's probably the case that they thought the Privileges and Immunities Clause would do all the work. That was the important clause, and that they thought some version of the privileges and immunities of citizenship meant things like free speech and the right to be free from unreasonable searches and seizures and all the other good stuff in the Bill of Rights. But really early on, in the 1870s, in the case called the Slaughterhouse cases, the Supreme Court read the Privileges and Immunities Clause really, really narrowly and said the only thing covered by the Privileges and Immunities Clause are privileges and immunities of federal citizenship. So it protects your right to vote in federal elections, but no other elections. And so that had the effect of basically denaturing the Privileges and Immunities Clause, which is why substantive due process was invented subsequently in the late 1890s, early part of the 20th century, to use the term liberty in the Due Process Clause to do the kind of work that the framers of the 14th Amendment thought the Privileges and Immunities Clause was going to do. Right. So it actually, I think, undermines Thomas's methodology, right? He thinks that he's a strict text and history guy. He thinks that these are just objective things. And his version of it is the correct objective one. But in fact, right, the Privilege and Immunities Clause was there, but then it was read to not basically not to mean what it was intended to mean. And then so they then at a later period picked up a different clause to do the same work that closer to the ideas that the framers of the 14th Amendment probably would have endorsed, right? So much more fluid, much more subject to interpretation than the Thomas view. Thomas is really odd to me, and he's one of the weakest of the justices, I think, and the most doctrinaire. And that's a sort of a kind of familiar kind of personality type that we all know people like this. Kind of the less they know, the more rigid they are about the things that they do know, right? And he's kind of that way. So even when he looks at the history, it's his version of the history, and of course his version of the history is the right version of the history, right? And that's the but that's part of the problem of relying on constitutional history. It's just it's the same as the problem of relying on constitutional text. The history is a text to be interpreted, and there are going to be different interpretations of what the history means, right? I wrote an article at the beginning of my career on the concept of standing, who has the right to bring a case that a court can hear. And one of the things that I showed was that at the time of the framers, there were a series of well-accepted procedural devices that allowed any citizen to sue on behalf of the public to enforce public rights. And that they didn't have to show any special interest or injury. And Thomas has, in a bunch of recent concurring opinions, embraced a distorted version of that history, saying that the rule ought to be different in public rights, but when you're suing on public rights, all you have to show is an injury, which is exactly the opposite of what I just told you. The history shows that's the so people see what the Simon and Garfunkel had it. The man hears what he wants to hear and disregards the rest.
Disregards the rest, yeah.
Yeah, questions, I think.
I have another one here. If judicial review and the Supreme Court is intrinsically undemocratic, what can we do to improve and revise the system?
God, I wish I had a good answer for that question. Can I quote Trump? You got to fight like hell. You won't have a country. I mean, that might be the only answer and maybe the best answer. I mean, I think there are things we could do. There are some structural reforms. The Biden appointed a commission on this question about how to reform the Supreme Court, which came up with a set of the most tepid and conventional answers. But there were a lot of submission, and the commission was intended, I think, like all governmental commissions, right? It's a way to defer the question and not act, right, to diffuse it politically and not actually deal with the problem, which is certainly how it played out in retrospect. But there were a lot of, good suggestions that commission considered and did not recommend. Probably the most obvious and the single, I wouldn't say it's the most important one, but the most important one that seems to me doable would be term limits.
Yeah.
It's right now the Supreme Court depends on when, who controls the Supreme Court depends on when people die, right?
Yeah.
Carter, right, got no appointees to the Supreme Court. Reagan got 3. Clinton got 2. Right, and Bush got, what was it, 3? Trump got, Obama got 2. Trump got 3. It's all happenstance, right? How it plays out. If you had, I think the details are, if you had a 17-year staggered terms, then every 2-term president would get 2 appointments. It would spread it out over time. That seems to me a really good solution. There are others. I mean, the best solution is for the Supreme Court to do what it ought to do and adopt the principles of judicial restraint that I referred to earlier, which is to defer to the political process unless what's at issue is essentially the fairness of the political process itself, in which case it should act to protect democracy. But that's an internal solution, as it were, right? That's not an external constraint on the court. The court has to adopt it and live up to it. Learned Hand, whom I mentioned a few moments ago, he was asked about Felix Frankfurter. And as I said, Felix Frankfurter was a strong advocate for judicial restraint, right? He said courts have limited judicial capital. We should spend it very parsimoniously. When asked about Felix Frankfurter, reportedly Learned Hand said he believes in judicial restraint. He hasn't any, but he believes. So, I mean, the problem with that solution is you got to pick the right people, right?
Right.
It has to be self-enforced. So the other possibility, which would require a constitutional amendment, obviously, is we could either do away with judicial review, or less radically, we could make judicial review subject to checks and balances. So Canada has judicial review, but it has a legislative override. So the Canadian Supreme Court can hold something unconstitutional under the charter, but if the Parliament disagrees, then by a supermajority vote, they can overrule the Supreme Court.
Oh.
And other democracies, not all democracies have that, but other democracies have and that would be consistent with our general conception of checks and balances, right? One of the problems of the Supreme Court is there is no checks and balances with the Supreme Court. Impeachment, in theory, could be, but it's not historically. when I was a young lawyer, one of the first things I did at in the West Legal Defense Fund was to write an amicus brief in the Supreme Court. And I was 25 at the time, and one of my senior colleagues pulled me aside. And he says, "Oh, I hear you're working on a Supreme Court brief in the Wolfish case." I said, "Yeah." He said, "Steve, you need to know one thing. The Supreme Court is an 800-pound gorilla, does whatever the hell it wants."
I have a question, and it may not be a 2-minute closing question, but I'm going to ask it anyway. So I think a number of us sitting around this Zoom online presentation, having grown up with thinking that the Supreme Court was honorable, that they were almost like the Pope's pontiffs, his circle of moral thinking people. But you have repeatedly said it's about politics. And it's not just about politics, universally, it's about their own personal politics.
Yeah.
Not. Am I going too far in interpreting who these people are and how they're making their decisions? Or is that kind of right?
You're kind of right. You're not going too far, but you're kind of a little bit too far. And I'll explain what I mean. So when I said it's always about politics, it doesn't necessarily, I did not mean to imply it's always about personal politics or it's always about political preference or partisan politics. It seems increasingly now that it is, but that's a measure of how far this Supreme Court has fallen, I would say. But I do think it was always about politics. But there's, I guess, let me just tell two stories. So I twice had the occasion to meet Justice Blackmun, right, the author of Roe. Justice Blackmun was not the smartest person on the Supreme Court when he was on. He did not have the best reputation as the smartest person. But I think he was a great justice. And the reason I think he was a great justice, on the second occasion, I got to talk with him at some great length, is this was a man who really was a patriot. He believed in public service. He believed in the United States. And he was a great justice because he understood his job was to do the best thing he could for the country, right? All things considered, right? And in a more old-fashioned idiom, it's gendered, right? He was a statesman. He understood his job was to behave in a statesman-like fashion. And I have to say, he impressed me. Now, his opinions don't impress me. Most of his opinions were written by his law clerks. But he understood what his job was. Justice Holmes actually said that quite explicitly in quintessential Holmes wry fashion. He said, if my fellow citizens want to go in hell in a handbasket, my job is to get them there faster. But I think that's right. So there's politics and there's politics, right? That's doing what you think is the best for the country, all things considered, from within the realm of your authority, seems to me is the right role for the. And we've had some great justices, if that's your one standard. That's my standard. Not justices that as a political matter, I don't always agree with. The second Justice Harlan, who was part of the Warren Court, was a little bit right of center. He was a moderate. But I love reading his opinions. I love teaching his opinions because he was smart and he was thoughtful and he was obviously not operating in a partisan way. Sometimes he thought what was best for the country is something different than I would think. But I always respect what he's saying and what he's doing, even if one disagrees. Justice Jackson, a little bit to the left, he was Roosevelt's attorney general, and he was the chief prosecutor at Nuremberg. But he was on the Supreme Court. He was a little bit left of where Harlan was, but also basically a moderate. But also, you just knew he was right? He was doing what he thought was best for the country. There's actually a famous opinion when Harry Truman nationalized the steel mills to settle the steel strike during the Korean War, and the Supreme Court held that the steel seizure cases, that he had exceeded his authority. Justice Jackson starts his opinion by saying, you know, the Constitution really, there's a bad paraphrase. He was a terrific writer, so his version is much better than what I'm about to say. He says, you know, you'd be surprised how little help the text of the Constitution and the history of the Constitution really are. And he says, as somebody who was a chief executive officer and often took strong positions that the president asked me to take, you know, there really is a dearth of material in terms of legal rules about. And then he has a brilliant concurring opinion. And one of the things that's, without going into the details, what's really interesting about it is Justice Black wrote the majority opinion, which 6 justices signed on to. There are 3 or 4 concurring opinions, of which Justice Jackson's is the only opinion that anybody ever cites. Every subsequent Supreme Court case on the question of the authority of the president under separation of powers immediately starts with Justice Jackson's concurring opinion, even though it only got 1 vote. And nobody pays any attention to Justice Black's opinion, which got 6, I'm holding up 5, but got 6 votes. Because Jackson's opinion was just that thoughtful. So we've had really smart, really thoughtful justices who, you know, were sort of they were acting politically. One of his points is there are zones that just have to be fought out between Congress and the president, right? That there's no final legal rule, that we have to, certain kinds of issues about whether the president has power have to be left to the political process. But so you can see why I liked it. But right, but yeah, we've had justice like that. I don't think that that's how most people, whether lay people or law professors, think of this Supreme Court. And you know, we can't even get them to disclose the hundreds of thousands of dollars of free gifts that they get, right? So that's
Right.
let alone to be confident that they're acting in a non-ideological way in the best interest of the republic.
This is one of those topics where we could talk for the next 2 hours, but I told people we'd be out by 8:30, so I think we're gonna have to leave it there.
Okay. I said one of my students is in the queue. And he points out that Canada also has an override by way of passing more specific legislation. So there's been more flexibility built into the Canadian system than ours. That would be a major change for us, but I do think that would be a net positive change. So it's fun talking with you all. And
Very nice.
It's been wonderful having you. Yes.
Thank you.
everybody take care.
Good night.
Good night.
Good night.